Good afternoon, everybody. This is Joe Perpelia, and I am President and CEO of ABC Eastern Pennsylvania. We know that this is a very challenging, confusing time in our industry, and I rest assured that ABC Eastern is doing everything that we can from a couple of fronts. One on the legislative side, trying to open construction back up beyond just the essential medical and healthcare and life-sustaining aspects. We're trying to get everyone back to work as quickly, but of course as safely as possible. And another main topic that has come our way is what are we doing from the legal side with sites and projects that have been put on hold very quickly and have also, might be in various stages of unrest based on how quickly things were shut down. And that is why I'm glad that Jonathan Landesman of Cohen Seglias, Palace, Greenhall, and Furman was able to make some time today to set up this webinar. And I think it'll be very useful. I know that questions are being received through the chat box. So if you have any questions, and I understand some are already coming in, which we're ready to address, if you could continue to do that, and we will answer them as quickly as we can while we are on the call. And with that, again, I want to thank Jonathan Landesman for his time and pass over to him to get this started.
Hey, Joe, thank you very much. And, as a labor and employment lawyer, I've been on the phone 24/7, for the last couple of weeks with contractors, and, they are asking a lot of the same questions. And so, we have this opportunity today to go over some of these questions and, hopefully respond to these questions en masse and provide some information that'll prove helpful for everyone. I hope that because I'm working remotely now, I hope everyone can see the screen because we have a PowerPoint to share with you. So let's go ahead and just and get to it. And because we have, I think, in excess of a couple hundred people on the phone, I think it's over 200 now. We want to hold our questions for the last 15 minutes or so, and I'll get to as many as I can. And the best way to ask those questions, as Joe mentioned, is just through the chat box. Let me see. It seems like we didn't. We don't have the screen up and running, so let me see if I can get that going. Hopefully you can see the screen now. Okay, good. So I'm told that we can. So now that we've got our technical glitch for this seminar in the rearview mirror, let's get to it. There's a picture of me. I know many of you. Let's talk about what we're going to actually get into today's agenda. So we're going to talk about the new federal law that was implemented, I guess, a week ago Wednesday, the Families First Coronavirus Response Act. I'll refer to it throughout the day, shorthand FFCRA. The FFCRA, as we'll talk about in detail, provides for mandatory paid family leave and paid sick leave, and it can have a huge impact on ABC contractors and really all employers. We're going to talk about unemployment compensation claims, workers' comp claims. We're going to talk about the WARN Act. What's the WARN Act? The WARN Act is a federal law that relates to layoffs and the notice that you have to give to the people in the event of certain layoffs. We're going to talk about the paycheck protection portion of the federal stimulus bill. And of course, the stimulus bill last weekend, there was a vote and it died in the Senate 47-47. But then on Wednesday, it passed the Senate, and we're expecting today for the stimulus to pass this afternoon and hopefully hit the president's desk tonight. It's a $2 trillion package, and it includes these payroll protection loans that could be key for a lot of our members when they're deciding how to, get through this time financially, and also with respect to layoffs. And then we'll talk about some other frequently asked questions that I've been fielding on a continuous basis from contractors. So let's start with the paid sick leave and paid family leave, that FFCRA. So it was signed into law in the evening on Wednesday, March 18. It requires small businesses to provide sick leave and family leave that's paid, and the effective date initially was set to be Thursday, next week on Thursday, April 2nd, but then on, I believe it was Wednesday, the Department of Labor pushed that up one day, so now we have to comply with it beginning April 1st, and it runs through the end of the year. Who does the FFCRA apply to? If your business has more than 500 employees, so if you're a large company, you don't have to worry about this law. The FFCRA doesn't apply to you. If your business has less than or fewer than 50 employees, then you may be exempt from the law. How are you exempt from the law? It's not just based on a head count. You have to apply to the Department of Labor and show the Department of Labor why complying with this law would threaten the ongoing viability of your business. That providing these benefits would be such a hardship that they might put you out of business. Where do you send your application? Is there a portal? Is there an email address? And on the contrary, the Department of Labor has issued a notice, and they said, sorry, we don't have a portal. We don't have any means of accepting applications for exemptions yet. And in that regard, the Department of Labor has been directed by Congress to publish regulations that fill in gaps. I mean, that's just one gap. We're going to talk about a few gaps as we go through this. So we're waiting for the Department of Labor to issue regulations and provide small employers with guidance on how they can seek this exemption if they feel that they need it. They've specifically said that writing letters and submitting emails to the Department of Labor's local field offices, there's one in Philadelphia, for example, those are going to be ignored. So that's not the way to get it done. So when you're providing, and we're going to go over in a few minutes, what the paid sick leave and paid family leave benefits are, I guess the good news is that that Uncle Sam is essentially picking up the tab for these benefits. And so how does that work? Essentially, what the FFCRA says is that for any benefits that an employer pays during a calendar quarter, when they file their 941 payroll tax return, they can take a credit, a dollar for dollar credit for any of these benefits that the employer provides. And then, there was a question from accountants, and I was speaking with an accountant earlier this week. Well, can you take that credit and make it an offset immediately on the return that you're filing? And the answer is yes, because the stimulus bill that was, that's going to be passed later today, as I mentioned. The stimulus bill specifically says that, and so you could take the credit immediately when you're filing the 941. Of course, if you don't have any payroll for that calendar quarter, and you can talk to your accountants about this more in detail, but if you don't have any payroll to take the credit against, then the credit would carry over to future payroll tax returns. So let's talk about the benefits that are available, the sick leave and the family leave. Those are the two parts. And what we're talking about here, and again, this is unprecedented on a federal level, we're talking about paid sick leave and paid family leave, not just unpaid leave like the FMLA. And there's provisions regarding the continuation of salary at a certain level, and provisions relating to the continuation of medical insurance benefits. So let's talk about and break it into two parts. First, I'm going to talk about the next couple of slides on this presentation, the paid sick leave, and then we'll talk about the paid family leave. And these things are a bit complicated, so that's why we want to break them down. The paid sick leave, it's 80 hours, which accounts for 2 weeks of leave. We can't take credit for or diminish other leave banks. So if you already give your employees 25 days of PTO time, you can't say, oh, well, I'm going to use those 25 days. You have to give them these 2 weeks on top of the 25 days using the example that I just went through. How much do we have to pay them for these 2 weeks? Well, it depends on the reason that the person is requesting leave. So we have to pay them their full salary up to $511 per day. That's the cap, if one of these three conditions apply. So essentially, if the person is quarantined pursuant to the government or by a doctor, or if the person is sick and seeking a medical diagnosis. They don't have to test positive. If they have flu-like symptoms and they're seeking medical diagnosis, then they get the 2 weeks basically at full pay, unless you're dealing with someone who's a really highly compensated employee that makes more than $511 per day. That's not per week, that's per day. Then there's a lesser amount of sick leave that's available in another three circumstances, and I have those outlined here. If you're caring for a spouse or a child who's quarantined, or if you have a child, a son or a daughter, who's under the age of 18 and either their school or daycare is closed, or there's and we sort of parroted the statute, if there's a substantially similar situation. So that's sort of the catch-all provision. In those instances, the person doesn't get the full pay capped at $511, but instead for the 2 weeks, they get 2/3 of their pay capped at $1,000 a week or $200 a day. So it's a lesser amount. So that's the paid sick leave. Let's look at paid family leave. So the paid family leave isn't 2 weeks, it's 12 weeks. Now, the first 2 weeks of the paid family leave are optional, and it's at the employee's option whether or not they want to get paid for it. They can use their paid sick leave that we just reviewed those provisions, or they can take it unpaid and save those 2 weeks of paid sick leave for another time. And unlike with the FMLA and other statutes, we don't get to dictate that as employers in our policy. Instead, it's the employee's option. The paid family leave is for the 12 weeks is the same $1,000 a week, $200 per day max, 2/3 of salary up to $200 per day max. When can you use the paid family leave? Who's eligible for it? If you look at the second bullet point here, caring for a son or daughter 18 or under. So whose school or daycare has been closed due to coronavirus. So let's take the hypothetical. You have employees and you're continuing to work on projects in Pennsylvania because they're considered life-sustaining projects. Here you have hospital work where you're working on a wastewater treatment plant, or you're doing work for a pharmaceutical, and the projects are ongoing. You have employees that are coming to work, they're getting paid. What's going to happen on April 1st to that workforce? Beginning on April 1st, if one of those employees or all of the employees has a child at home who's 18 or younger and their school is closed, and virtually all the schools are closed, they can call out and say, I'm not coming to work. I'm taking my federally entitled FFCRA paid family leave, and now you have to pay me pursuant to these provisions that we just reviewed, which is essentially $1,000 a week plus benefits for 12 weeks. That's for people, and again, I have the eligibility here. It's for people who are employed at least 30 days with your company, and it's only for active employees. So if you laid off people, those people do not get entitlement to the FFCRA benefits. And again, this goes into effect next week on Wednesday. So as I'm talking with dozens and dozens of contractors, what's the decision that they're making in their mind? They're trying to estimate and say, well, if I don't lay people off on April 1st, am I going to get this deluge of applications from people who want to take FFCRA family leave, and I'm going to have to give it to them? And the answer is that's a real possibility. And so some employers are timing their layoffs so that they happen before that April 1 date. Certainly a factor that employers need to consider. When we're talking about FFCRA compliance, we don't even have the regulations yet, I just said, and there's a lot of questions that we could get on this and the details of it. The Department of Labor has offered some I guess, assistance or good news here, and that is that yesterday, and again, these things are changing every day, but just yesterday, the Department of Labor issued guidance saying that they're not going to seek to penalize or commence litigation or enforcement actions against employers for unintentional violations, so long as they make a good faith effort to comply. So they want to see that the employer is at least trying. The other thing, and it didn't make it into this slide because it just happened late yesterday, is that the Department of Labor has published now and issued a workplace poster. So we all have those posters somewhere in the break room where we put them in a job site trailer. Now there's an FFCRA poster that if you're doing work or if your business is operating, you should go on the DOL website, dol.gov, and download that and make sure you post it. That's one easy way to show that you're attempting to make a good faith effort to comply with the law. Let's move away from the FFCRA. We could talk about that probably for a full hour with the intricacies of it, but there's a lot of other things to talk about, and we've got an hour's worth of time. So let's talk about unemployment compensation. What's going on now with unemployment comp? What's new? So, the general thing to understand is that if we lay people off and we shut things down due to something that's related to coronavirus, we can expect that people are going to file for benefits and they'll generally be deemed eligible. That's the same in Pennsylvania, New Jersey, and virtually all jurisdictions. Specific to Pennsylvania had always had a 7-day waiting period. So I'm an employee, I file a claim for benefits, I have to wait for 7 days till I start accruing unemployment comp benefits. Now that 7-day waiting period has been done away with, so that people can start getting their benefits immediately. That's the good news for the employees. What's the good news for the employer? The good news for the employer is that to the extent that people file unemployment comp claims that work for you, and those claims are related to coronavirus, your unemployment compensation tax rate isn't going to be charged. You're not going to see increases because of all those claims. So that's some relief from the state for employers. The other thing is that the stimulus package, that again it's not a question of whether it's going to be passed today. It will be passed and signed into law today. That provides for additional unemployment comp, and we'll go over that. I have a few slides later. There's an extension of the number of weeks, an extra 13 weeks, and an additional benefit on top of the benefit that people would otherwise receive. So, what's the benefit? How do they calculate unemployment comp? It's generally 2/3 of the person's wages, but it's capped at 2/3 of the state average weekly wage. So the benefit right now, I don't know the exact amount, it fluctuates every year because it's tied to that formula, let's say it's $660 a week or something like that is the maximum state benefit, and don't quote me on that number, but it's in that range. On top of that, now once the stimulus goes into effect, the people will get $600, a maximum of that on top of it. So you're looking at an unemployment benefit that exceeds $1,200 a week. And there was some debate before the stimulus package actually got finalized as to whether that's too rich of a benefit, and if it provides a perverse incentive for people to get laid off instead of want to go to work. Because if you're getting $1,200 plus a week, in most cases for a lot of working people, they can pay the bills with that amount, and they don't have the stress of being in a rush to get back to work. What if I have an employee, let's say that, again, I'm working on a life-sustaining project on a hospital. I'm open for business, but I have an employee who says, I don't want to come to work. The world is upside down. I'm not leaving my house. I don't want to come to work. Is that person allowed to file for unemployment? Well, sure, they can file for unemployment. Will they be granted benefits? We would hope that they would not be granted benefits in that situation, because then the risk for the employer is that all of the employees' coworkers are going to follow suit, and they'll all file. The standard that the unemployment comp people use is whether or not the employee has a necessitous and compelling reason. That's a quote from the unemployment comp statute. It basically means a good reason for not coming into work. And, just because the pandemic is, I say just, but the mere fact that the pandemic is out there doesn't constitute, in all likelihood, a necessitous and compelling reason for employees to refuse to come to work if their businesses are exempted. If it did, then you could have people in the medical field or other fields just refuse to come to work, including in emergency construction, refuse to come to work, and the employer would have no recourse. That being said, I sort of couched my response there or comments as saying, in all likelihood. Why did I say that? Because we don't know for sure. Things are evolving. We don't know for sure how the unemployment comp people are going to process this. There's a possibility that they'll start deeming them eligible. But, based on our reading of the law and my team of employment lawyers, we've been looking at all these questions and researching it. We believe that the people should not be eligible. There's sort of a related concept under OSHA, and I'm not going to take a lot of time, but as a general rule, employees under OSHA's rules are allowed or permitted to say, no, I'm not coming to work, if the employee can establish that coming to work would pose an imminent threat to the employee's safety and well-being. Well, in this case, does the pandemic create an imminent threat to all workplaces? We don't think that OSHA would be interpreted in that way. We believe that OSHA would be interpreted to mean that if there was some special circumstance at a particular employer's work site or offices, like someone tested positive, you could make an argument that an imminent threat would exist until the employer abates the situation by going out and getting industrial cleaning done or something like that. But just in the ordinary course, we don't think that employees can refuse to come to work if the employer is operating, relying upon that imminent threat OSHA rule. So that's unemployment comp. And again, I'll make a few comments about the enhanced benefits under the stimulus bill. Let's move along. We're trying to move quickly through these things. Workers' compensation. So if one of your employees comes up with a positive test for coronavirus, are they going to be able to file a claim for workers' comp benefits and receive both the medical and wage loss benefits that are available under workers' comp laws? The Department of Labor has issued guidance, and the answer is, in the vast, vast majority of cases, employees who file workers' comp claims. I'm not talking about unemployment. I'm talking about workers' comp now. Workers' comp claims for coronavirus. Those claim petitions are going to be denied. It looks like the standard is going to be, one that the employee would really have to bear a high burden of showing that, that the virus was related to work, that they contracted the virus at work as opposed to somewhere else, and that proof standard is a very very difficult one. I'm just looking here, and I'm getting news alerts that the stimulus package actually within the last hour did pass. So I had read up on it this morning, and I knew they were calling for a voice vote in the House, and apparently that's happened. And so as we're sitting here within the last hour, the stimulus package did pass, and so I imagine that's on its way to President Trump's desk right now for final signature. So that is actually a good segue to the next group of slides when we're talking about the stimulus law, and they called it CARES, the Corona Act, and I'm not sure, and I don't have it here exactly what the acronym stands for, but the law is referred to as CARES, and I mentioned earlier that it was passed through the Senate. This slide is now outdated, where it says it still requires House approval, and will have the president's signature. And there's a couple of provisions that are very important. I mean, there's provisions that make the news and talk about, deferring or forgiving in part student loans and providing employees, or not employees, individuals with income caps, certain amounts of one-time checks, essentially going out for singles and for married individuals. I'm not going to be focusing on that. I'm really focusing on two provisions of CARES, or two provisions of the Stimulus Act. The first is the Paycheck Protection Loans, which I think is important to so many of the ABC chapter members, or could have a very significant impact. And then the expansion of unemployment comp, which I've already gone over in part. So first, let's talk about these paycheck protection loans. So there's a typo here. It says $349 million earmarked. And again, we put this together very, very quickly, so I apologize for that. That M should be a B. It's $349 billion, and that's so that represents a significant percentage of the $2 trillion that is included in this CARES package. Who's eligible for these paycheck protection loans? So it's only small businesses. So if you have 500 or more employees, you're not going to be deemed eligible. And the loans are only eligible for businesses who can certify that they need the loans to maintain their operations in the midst of this pandemic. What can you use the loans for? What are the amounts? What are the terms of forgiveness of the loans, which is the biggest question of all. So forgivable loan, of course, means you don't have to pay it back. It's the debt's forgiven. So let's talk about that. So the SBA is who's administering the loans, and the loans are going to be made by participating banks and credit unions. I understand that the loans also are going to be administered directly through the SBA, or at least I heard an accountant tell me that this morning. And the loans will be administered through June 30 of this year. They are specifically designed essentially to incentivize businesses not to lay people off. It's a payroll protection. So we can use the loans to pay employees, and that's capped at $100,000 prorated annually, as well as health insurance, 401k contributions, and fringe benefits. And we'll go over, there's other things you can use these loans for. What's the maximum amount of the loan that any given business is allowed to take out. It's either 2.5 times your payroll costs, or $10 million, the lesser of those two. So what can I use the loan for? I can use the loan to cover payroll costs, insurance, as I mentioned, commissions, things like that, interest payments on certain mortgage obligations, of course, that are related to your business, the business's rent, utilities, and other debt obligations that you have, interest on a note or a line of credit that you have. So what portion of the loan would be forgiven, or it could be substantially all of the loan. The loan is basically, it's not for an indefinite period of time. The loan proceeds are to be used for a, quote, covered period. And what's the covered period? The covered period is the 8-week period immediately following the origination of the loan. So that's anything that's expended from the loan during those 8 weeks, that's what is forgivable. But what are the conditions to have the loan forgiven by the federal government? There's a few tests and terms and conditions which are very technical in the bill, but basically what they're designed to do is make sure that you're not laying off people or cutting people's salaries too much. Because if you lay people off, the more you lay people off, the lower your employee headcount, the more of the loan you have to pay back. And the equation to figure out the percentage that's applied to the loan forgiveness is set forth in this second bullet point. And in plain English, what it is you look at the number of employees you have on average per month during that 8-week period that again is the covered period following the loan origination. So let's say and I'll use an example just to sort of illuminate this. Let's say I have 75 employees during that 8-week period. That is the numerator in our fraction to determine this percentage. What's the denominator? The denominator is the number of employees that I have. There's two different ways. It can be the number of employees I have in the first 2 months of the year, January and February. So let's say I had 100 employees on average in January and February. I get a loan beginning in March, and during that 8-week period, I originate the loan rather on March 1st. And my example isn't a good one because we couldn't originate the loan before this program goes into effect. But in any event, using the hypothetical, I originate the loan on April 1st to change it. And for 8 weeks, my average is 75 employees during that 8-week period. But in January and February, I had 100 employees on average. Well, then only 75% of the loan would be forgiven by the government. I'd have to pay back 25% of the loan. And instead of using the first 2 months of the year as your denominator, the bill allows for you to use essentially a 6-month period in 2019, from February to June of 2019 as your denominator, if that's more favorable. Some other restrictions, and these are things that you should really go over with your banker. And so I'm recommending to clients that even though all the big banks, and I know that some of our clients have reached out to a number of them, their bankers are telling them that, their legal departments are digesting this, and, it's got to go from the legal departments at the headquarters and get filtered down to the underwriters and actually the loan officers. And hopefully that'll happen within the next week or so, and people will be ready at the banks to deal with this flood of applications for these loans. But it's a good idea, if you have a good relationship with a banker, to call them and give them a heads up and let them know that you want to be first in line to be considered for these, and you want to get your application in as quickly as possible. anyway, back to some of the conditions for loan forgiveness. It's not just based on that test for employee headcount that I just went over, but if you cut people's salary by more than 25%, that could also lead to a reduction in the amount of the loan that can be forgiven. Let's talk and move away from the CARES provision, from the stimulus package provisions that deal with the loans. Now let's talk about the unemployment comp. And I've got a lot of information here, so I want to move through it rather quickly. There's an additional 13 weeks, so that's tacked on to the eligibility right now, and then it's a supplement of an additional $600 per week max on top of what the state benefit is. So we could see people, as I mentioned earlier, getting a maximum benefit when you combine it for unemployment comp purposes of $1,200 plus a week, which is an unprecedented level of unemployment compensation benefits designed again to keep people spending money, to keep the economy moving. So we have eligibility, and it says for up to 39 weeks. That's the additional 13 weeks that I mentioned earlier, which would be in addition to the 26-week ordinary eligibility. And it mentions here again the $600 supplement, and that being available to people through July of 2020, it says. Let's switch gears and move away from the stimulus package, because I know that there are a lot of questions from the people on the line, and I want to try to get to as many of them as I can. So I'll just go through a few additional points, and then we'll save about 15 minutes for questions. So I've been asked questions from clients. John, I need to conduct a layoff. I've got 7 people in my accounting department. How do I decide who to lay off and who to keep? I need a few, but I'm not going to get rid of all of them. So there are considerations whenever you're terminating an employee, whether it's a layoff or a termination for cause. We want to make sure that you're not creating a situation where you're susceptible to an allegation for discrimination. It's obvious you wouldn't want to lay off just all of the racial minorities or ethnic minorities. You wouldn't want to lay off all the women and keep all the men, or vice versa. What's the safest path? A lot of companies will use seniority when they're laying people off. So the last people hired are the first people out the door. Other clients say, I can't use seniority because I want to keep my best people. Seniority doesn't necessarily work. If you're making decisions and you're not using seniority, the best advice that I could give a client is make sure that you're able to defend that decision, because the people who are selected for layoff can and do bring claims in these situations. And I guess I should mention, it's usually not gender or gender-based claims or claims based on race or ethnicity. Typically, what you see, and there's a lot of litigation on this, it's age-based claims. The person says, I got laid off because I was the oldest person, and look, you laid off all of the older people. And employers fall into a trap when they say, I'm going to lay off all the people who are my highest paid people first. While that might seem to make sense and it might seem legitimate, usually that rule, if you're going to just pick the highest paid people, it falls more heavily on older workers, and that, of course, is where you want to watch out for that. When you're laying people off, and this might seem like a secondary concern, but I have had clients ask me about it. I've got a highly compensated employee, a salesperson, or an estimator, project manager who has a lot of customer relationships. If I lay them off, can I hold them to their non-compete? The answer in Pennsylvania is you may still be able to hold them to their non-compete, but courts weigh a whole bunch of factors when trying to evaluate whether a non-compete is enforceable. And that would be one factor that would militate against the employer, against enforcement, but it's not an absolute bar to enforcing a non-compete. I put a bullet in there about thinking about the loan forgiveness of the stimulus package, and we had just talked about that. So an employer who is thinking about layoffs, you want to think about the layoffs in terms of both of the major laws that we just talked about. How is that going to impact any loan that you take and your eligibility for loan forgiveness, number one. And number two, if you lay people off and you wait until after the April 1st deadline, you're going to have a lot of people who are submitting requests to take FFCRA family leave, paid family leave. And by the way, if the April 1st deadline comes and goes and you have a bunch of people who are on paid family leave, but you're going to lay off all the people, are those people who are on family leave somehow exempt? Do they continue to get FFCRA benefits? And the answer is no. If you were going to lay everybody off, you'd lay off all of the people, including the people on leave, and then they would simply become eligible for unemployment comp benefits. Let's talk about the WARN Act. What's the WARN Act? Is it a law that people talk about a lot? Not really, because it only applies in situations with mass layoffs, a covered layoff. So what's a mass layoff? If I'm laying off 500 people, that's a mass layoff. If I'm laying off 50 employees at a site and it makes up a third of the total workforce, that's also a mass layoff. So let's say that I have 200 employees who work, for a company with, at a location in Montgomery County. I have 200 employees there. How many employees would I need to lay off? So it's a mass layoff. If it's 50, that's not enough, because even though I hit the 50 threshold, it's got to be 50 and 1/3. So at that particular site, 50 plus and 1/3 would be, 200 divided by 3 would be 67 employees would be the minimum in order to trigger the WARN obligation. What's the WARN obligation? And by the way, the WARN obligation only applies to a layoff when I'm laying people off and they're going to be out for at least 6 months, or a permanent layoff. When I lay someone off under WARN, WARN says I need to provide them with 60 days notice prior. I need to warn them. It's a pro-employee. I need to give them 60 days notice before the layoff. Well, what happens if I don't give them 60 days notice? Well, you're supposed to give them 60 days of pay, and if you fail to do so, there's a $500 per employee penalty plus other administrative penalties and attorney's fees, and it adds up very, very quickly. So what are all these employers doing to satisfy their WARN Act obligations? Well, there are exceptions to WARN. There's a natural disaster exception. Is coronavirus, is the pandemic a natural disaster? Probably not, because there's a lot of cases out there that say that natural disasters are only things that have a physical impact on the business, like tornadoes or hurricanes. There's also an unforeseen business circumstances exception, which has been very narrowly tailored. A lot of employers are relying on that. Unfortunately, the Department of Labor hasn't released any guidance on that. So we're still waiting at a federal level to see whether or not an employer can rely on that unforeseen business circumstance exception and not give them WARN notices. A lot of businesses are relying on that, even in the absence of that guidance from the federal Department of Labor. In that regard, there are many states like New Jersey, California, that have their own versions of the WARN Act. And the California governor recently issued an executive order saying that you do not have to give 60 days notice under the California WARN Act for for layoffs. And again, it remains to be seen whether or not other states and if the federal government are going to follow that. You'd hope that they do for the employer community, or it could be a very significant issue. Let's talk about some additional questions real quickly, and then we'll go to the questions that we have in the instant messaging here. When do we require, can we require employees to disclose positive tests? Yes, we can. If there's a positive test, who should we tell? Where there should be communications at a minimum to the CDC, the local Department of Health, other employees who are in contact, and perhaps, others, if it's a job site, subcontractors, things like that. So we should make those disclosures. When making the disclosure, we should respect people's privacy and their rights under HIPAA to avoid violations, and not disclose names to the extent we can. Do we have a right to take people's temperature? So nobody's going to be allowed at this job site unless at the gate we take your temperature and you have less than 100.4. EEOC issued guidance on this, thankfully, and essentially said, yes, we can take people's temperature. The only problem is, obviously we can't find enough thermometers out there to get that done. I have one manufacturing client, and they went out and they hired a nurse at a great expense for the next 3 months to sit and screen all the people as they're coming into the factory. Can we send employees home if they're coughing or exhibit flu-like symptoms or coronavirus-like symptoms? And the answer is, it may seem like common sense, but I've had this question. The answer is a resounding yes. We have a duty and an obligation, actually, to protect our other people. So now I'm going to turn to some of the questions that we have, and I've got many of them. So I'm just going to sort of pick through and see which questions that we have. So I've got a question here from a contractor that says, when construction is able to go back to work, what can we do if an employee refuses to go back to work? So we had touched on this question. The answer is, unless the employee can show that there's some sort of imminent threat, which in most cases they won't be able to and satisfy that standard under OSHA, in most cases an employer can insist that the employee return. And if the employee fails to return, there can be consequences under our attendance policy. So if you're not coming into work and there's work that's available for you, we're going to discipline you, and it's ultimately going to lead to termination of employment. Let's see. I've got a question here from another contractor. How does the FMLA pertain to union contractors? I assume what we're talking about here is the FFCRA, which technically is an amendment to the FMLA. And the answer is that union contractors and non-union contractors need to provide these benefits. And so to the extent that all or part of your business is operated with union employees, those employees get the same benefits that I described in our presentation earlier. So they get the paid sick leave and the paid family leave. Let's see. I'm just going through some of these questions. Here's another one. The FFCRA may exempt employers under 50 employees, but will this just be for leave taken, for childcare or school closings, meaning all employers under 500 have to provide at least 80 hours of sick leave for all other COVID-related absences? So my understanding is that the exemption applies equally to paid sick leave and paid family leave if you qualify for it. That's something that I think we can we can clarify, and we'll wait for the guidance to make sure that that's the DOL's guidance through its regulations. But that's my understanding of the reading of the statute is that if you qualify for the exemption, you're exempt from both. Let's see this next question here. Does the Pennsylvania Governor Wolf's order to close physical operations of non-life sustaining businesses and or the stay-at-home order constitute an isolation or quarantine order in terms of the FFCRA weeks of extra sick leave? So, the question is, and we said earlier, an individual can take the 2 weeks of sick leave and get full pay up to $511 per week if they're quarantined by a state, federal, or local authority. Are the current orders that are in place, do they satisfy that? And again, we don't have definitive guidance from the Department of Labor, but we've considered that question. And when I say we, I mean me and the team of employment attorneys that I work with at Cohen Seglias, and we've determined that the answer to that question is that the answer is no. The current executive orders that are in place don't entitle every single employee in the Commonwealth of Pennsylvania to take the 2 weeks of leave at full pay. We don't think that's how the statute reads or will be interpreted. We could be surprised when the Department of Labor issues its regulations, but right now, we're relying on that, and we're saying that we can tell the people to come back to work, and they can't rely on the current orders that are in place. Let's take a look at another question. Again, I'm not going to get to all of these, but I'm going to go through as many as I can. How does the 50 employee count for exempt status work for applicable large employers with common ownership? Is there a mile radius set forth in this count? So there are specific provisions in the statute that talk about how you count the 50 employees and counting part-time versus full-time people. But I believe that when we're looking at that exemption, we're not looking at a site-specific headcount. If an employer has branch offices in Philly, Harrisburg, Pittsburgh, Baltimore, or wherever, we would aggregate the number of employees for purposes of that 50 employee exemption. So if in aggregate you had more than 50 employees, I don't think you'd be eligible for the exemption. Again, and I hate to be a broken record on this, we're still waiting for guidance on a lot of these things. There's a question here as to whether or not we're going to share our PowerPoint slides. So the answer is, I believe, yes, we will share them and distribute them to everyone. And in that regard, because we're trying to get the word out to as many people as possible, on my firm's website, which is cohenseglias.com, if you look at the website, there's a section there, and maybe I can pull it up and everyone can see it. I don't know if people are able to view what I'm looking at, but this is the website. And if you go to news and events, and then there's COVID-19 resources, and you can see that there's a lot of information that we're trying to put out there, including a summary of some of the laws that we've gone over, but then also things about force majeure and a lot of issues that contractors are facing right now from a construction law perspective. I think we have one also specifically for federal projects. So I'd encourage you to look at those free resources to take advantage of them. Let me just pull up the PowerPoint again here. Okay, so let's see the other questions that we have here, and we do have a lot of them. Here's one. The FFCRA notes that government-ordered isolation is a qualifying reason for paid sick leave. Do the current stay-at-home orders in PA qualify as reason to get the 2 weeks? I've already answered that question, so let me move on to another one. Let's see. Another question from a contractor. We already laid off our field employees last week when Governor Wolf issued his shutdown order. Those employees have already filed for unemployment. Are they eligible for compensation, or should they remain on unemployment? So the people who have already been laid off, they're going to get unemployment compensation. Their unemployment comp benefits will be enhanced when the stimulus enhancement goes into effect, and I don't know the exact date of that, but again, it's up to an additional $600 per week, extended for additional weeks beyond what they would otherwise receive. They will not get FFCRA benefits. They're not going to get these paid leave benefits unless and until you call them back to work. Here's another contractor with a question. Obviously, every dollar payroll tax credit represents over $14 of payroll. 2 weeks of payroll will take approximately 28 weeks to recover based solely on federal payroll tax credits. Will there be refunds along the way to help with cash flow? And I think that that's a question that I've had from so many contractors, especially smaller contractors, who are saying that the tax credit, that's all well and good, but I don't have the cash on hand to lay out all this money and for the benefits and for the payroll tax and for the payroll. I don't have the money to do all of that and then wait to file my quarterly tax return, essentially to get a credit, to get it back. And my understanding is that there's not going to be money that's doled out along the way to help people. The only real relief is if you have less than 50 employees, you can file for an exemption. Otherwise, I don't see an avenue there for relief, unfortunately. And like I said, on or after April 1st, I think a lot of employers can expect employees to have a problem. Here's a question from another contractor, and I think it may be our last question. We've been deemed essential. We furloughed our hourly workforce this past Monday because we didn't know how we could schedule new work. Now we're calling people back into work. They are intermittently working. Will that mean that they'll be considered active employees for the FFCRA? So you have people that you laid off or you furloughed. By the way, what's the difference between a layoff and a furlough? Typically, a furlough means that I'm carrying their benefits, although a lot of times the terms are used intermittently. So I have people who are laid off and then I bring them back. Are they going to be eligible on April 1 for the FFCRA benefits? And the answer is yes, they will be. That's how the law works. So when you bring the people back, they will be eligible for benefits. So I know that everyone is very busy during this hectic time. I hope that the information that we were able to provide to you was helpful. We're going to continue publishing information on a regular basis. I think in the last week and a half, I've published 3 articles on my firm's website about these issues. We'll continue to do so and provide more information. I wasn't able to get to every question. And if you want to ask me questions, of course, feel free to reach out to me. You should all be seeing now the slide that has my contact information, including my cell phone number. So with that, Joe, did you want to make any closing remarks before we end the presentation today? I don't know if Joe Propelia is...
Just one thing. Yep, just one thing, Jonathan. Again, thank you for putting all this together. I know it was done rapidly, but done very well. And I just to pass along the same sentiments I've been putting out on LinkedIn and on our website. Just everybody, please stay safe and know that ABC Eastern, along with all the other ABC chapters, ABC of Pennsylvania, are working to try to get us back to work as quickly and as safely as possible. It's a little bit of an uphill battle at the moment. I know that the governor's pretty dug in on his order, but we are doing what we can daily, multiple times daily, to try to open things back up. But also, again, keeping in mind that everybody returns to work safely under proper safety protocols, and that we don't put anybody in harm's way. So, with that, I hope everybody has a great weekend. And ABC Eastern is here as a resource. Again, thanks, Jonathan, for putting this together, and his team for putting this together. And I hope you all have a safe day.
Thanks, Joe.